Ain't nothing but a heartache. Tell me why. I never wanna hear you say I want it that way. All right, we're live. Good morning. Rise and shine. Good afternoon, good morning, welcome. Thank you for joining me. We're here and we're, can't say it. No volume. Why don't you have any volume? You must have your volume turned down. Good morning. All right, so we're going to watch this evidentiary hearing. Taylor Schuabusiness. All right. That comb over starting again. Yeah, this hair, I can't control it, man. This shit it does what it wants. I can't control anything. This thing it's just a lop on my head. It gets to that point every time where it's just like whatever. It's just, I can't even control it. The mop on my head. What are you guys talking about? No sound. I see my levels here. Y'all need to turn the two people in the chat. Gotta turn that volume up. So yeah, Taylor Schuabusiness. I just posted a video this morning. Brief video. I recorded it last night. I just read the criminal complaint. And law and crime, which I meant to kind of work on the screen, but I think as the trial starts, we'll work on something together. All right, we got to put video mail away. We'll work on something together for the trial. We'll fix a good screen. I don't know what we'll try to do something. I don't know what. And I'll have to fill up all the black spots or whatever. I'm assuming the trial is going to happen. I think the judge was supposed to decide today whether it's going to happen. They've had like a competency, if you want to call it that, I don't know what they call it, hearing before, and she was deemed competent. And so I guess she's trying to wiggle her way out. For the people that don't know the story, I posted it this morning. I made a playlist. If the trial starts, I'm going to put the playlist into my front page of YouTube. This the heifer that got high with her boyfriend, or I don't know if they're boyfriends or they keep calling him a lover. I don't know. She got high with this guy, and I had his name here. Hold on a second. And I was saying earlier too, we're gonna get into all the details like once the trial starts. Shad Tharion. We'll get into all the details as the trial starts and all the stuff. We'll have lunch breaks and everything, and we can get into the side story and whatever else. But so they got high, they did meth, you know what I'm saying? And well, she called it the bitch. They smoked the bitch. And she claims he pulled out 2 chains, metal chain link chains, and I guess she started choking the guy, and she said she liked it, and like she could see his heart beating, and started coughing up blood, and it gets very graphic, very detailed. And she just said she claims she blacked out. She came back. She kept choked him to death. And after this guy is deceased, okay, for hours, she played with his body in sexual ways, okay? So, yeah. Denise says, yes, trial starts Monday. Jury selection begins in an hour or two. Okay, cool. And I'm not streaming the jury selection. I don't even know if they're going to stream that. A lot of the times they don't. Sometimes they just put the audio. I'm not streaming the jury selection, but what I will do is tonight, I'll set the stream for Monday morning. And so for the people wondering, it's at 9:15 a.m. Eastern, which is 8:15 Central, which is what, 6:15 Pacific, California time. Okay, so it's gonna be early morning. All right. So we're just going through the motions now in preparation for the trial, just to let everybody know so they don't say on Monday, I didn't know you were streaming, Bell. We've been talking about it for days, okay? Everybody have enough warning and heads up, advance time. I got a headache for some reason. This last couple of days I've been getting, oh, damn. Hey, oh, shit, she's smiling too. Oh, look. Hold on, let me see this shit. Hold on. Lord almighty. She's smiling. See, I've been crazy, but I never this level. You know what I'm saying? Oh, hell nah, bro. You see that look on her face?
Nobody can hear that.
Ooh. Is that the same guy that tackled her? That had to hold her down when she went crazy and attacked her lawyer? Don't worry. I'm gonna turn up the volume. Oh, hell nah, bro. You seen that? Good. Don't worry, I will turn up the volume. You guys can hear the whispers in the court. Oh, bro. Wow, dude. Wow, that's a scary woman right there, bro. You been getting headaches too, Carly? I don't know what's going on. Are we dying? I don't think I've been drinking enough water. I got a whole thing of water this morning. I filled it up.
Morning. Good, you?
Morning.
Dr. Layton for several hours. 3 last night. I took a fan for treatment, right? What's today?
Oh, it's pumped up so you guys can hear the keys dangling or whatever's going on in the background. Oh, we'll talk about Sarah Boone too. Court TV did a little stream. I don't think that's gonna. They were supposed to start the same time this trial. I don't think it's gonna happen though. Right now, it's been postponed so many times. But remind me at the end of this for us to check out what's going on with Sarah.
Yeah, I just like that. I appreciate it. Absolutely.
Yeah, you gotta stay real close. This woman. Yeah, I gotta have her handcuffed to the seat. Yeah, they got that, man. Whatever that is. Stainless steel, titanium. What was that? Carbon fiber? Carbon fiber, whatever. Whew. Then they got a big ass ring around her. Or, yeah, like a belt ring thing that holds her arms too. Wow. Oh, thank you, B. It was pushed back to Philosophy October 2nd. Okay. Oh, Lord, bruh. Imagine that bringing home to mama. Ooh. Gotta be crazy being high with that chick too. Oh my god. Host said I used to think I had a humor until I cracked up the dehumidifier at night. Ooh. Q-Tipa, migraine prevention. Was a miracle cure, really? My dad used to get really bad migraines. I could fast forward this. I mean, I don't know why I'm here listening to this. Let's see.
8:30.
This happened like an hour ago, 2 hours ago, something like that. I just wanted to give time to give you guys a chance to watch the complaint video before you watch this, so whoever needed to get an idea what's going on can know what's going on.
Silence is requested.
Be seated.
There we go.
Okay. I'll call CF 363, State of Wisconsin versus Taylor Schabusiness. State appears by Deputy District Attorney Saunders and District Attorney Lizay. Also appearing is the defendant, Ms. Schabusiness, Mr. Fred. Here today, or this morning, a continuation of the competency hearing. And the court has now received a copy of the report from the Wisconsin Forensic Unit, Dr. Seipel. He's here on the Zoom. Did both parties receive a copy, Mr. Saunders?
Yes.
Mr. Freilich?
Yes, I did, and I reviewed it with my client.
Very good. So I think that's where we will pick up, because we had the first half of this hearing last week. That was Dr. Lighton testifying. I know that she's on the
Thank you, Butterfly.
Zoom as well. So
Butterfly says there's not going to be any live streaming of jury selection per the judge. Okay, perfect.
Mr. Freilich may or may not choose to call her in rebuttal. Thank you. Afterwards. But I think I'd turn the case over to you. Do you want to initially direct Dr. Seipel, Mr. Saunders?
I'll take care of questioning this morning, Your Honor.
Mr. Lizet, then are you going to call Dr. Seipel then?
Yes, I am, Your Honor.
Okay, doctor, if you could please raise your right hand, I'm going to place you under oath. Do you swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very good. Mr. Lizet, the witness is yours.
Thank you. Dr. Seipel, can you state for the record how you are currently employed?
I am employed as a licensed psychologist with Behavioral Consultants Incorporated in the Wisconsin Forensic Unit, where I perform forensic mental health evaluations, including competency to proceed, on a full-time basis.
And how long have you worked at the Wisconsin Forensic Unit?
So I began with the Forensic Unit as a postdoctoral forensic psychology fellow in September.
Okay, I'll try to bump it up a little bit. It's going to be a bitch because I guess the TV's at a distance, the microphone's by the attorney, so the volume's not great. So we're going to hear the attorney really loud while this low, I guess. So I'll just bump it up. Hopefully it's not too much.
2020, and I've continued with the practice since obtaining my psychology license in February of 2022.
Could you estimate approximately how many court-ordered competency evaluations you have performed over the course of your career?
It is approximately 800 to date.
And have you been accepted in Wisconsin courts as an expert or as a witness on the issue of competency to proceed in criminal cases?
Yes, I have.
And in fact, you previously testified in this case, State of Wisconsin versus Taylor Schabusiness. Is that correct?
Yes, on 2 occasions I provided testimony in this matter.
And on those occasions, did you provide testimony regarding your background and your licensing?
Yes.
And the background information generally that you provided in that testimony, does that remain accurate here today?
Yes, there's been no changes to my licensure status or any of my employment or professional affiliations.
Thank you. And Dr. Seipel, you were then subsequently asked by the court in this case to provide an additional competency evaluation. Is that correct?
Yes.
Can you just briefly address the additional materials that you reviewed in order to prepare the present report?
Yes, so in order to prepare the present report regarding the defendant's competency to proceed, I performed a direct in-person examination of the defendant. And that occurred on July 12th within the Brown County Jail. I again reviewed the criminal complaint for this case and discussed portions thereof with the defendant in the evaluation. I reviewed all of the competency and criminal responsibility evaluations completed to date in this case. I reviewed updated records from the jail medical service. I reviewed a discharge summary from the defendant's previous treatment at the Brown County Nicolay Psychiatric Center. And I also spoke with defense counsel regarding recent observations and concerns, as well as reviewed the motions that were provided to me by defense counsel requesting new competency evaluations.
After all of that additional document review,
They requested another one because they're trying to sliver out of this shit, I guess. They requested another, if I'm hearing that right. I'm making a thumbnail for Monday morning. Another competency. They're trying to slither.
the discussions that you had and the in-person meeting that you had with Ms. Schabusiness, did you ultimately form a conclusion regarding her competency to proceed in this criminal case?
Yes, I did.
And did you prepare a report that discussed those conclusions and the bases for those conclusions?
Yes, I did.
And is that report a letter to the court dated July 17th of 2023 that you provided to the court?
Yes.
Again, that report is 20 pages in length, is that correct?
Yes.
Your Honor, I believe that all of the parties are looking at document 223. I would just ask for the record that this be marked as an exhibit, or I don't know if it necessarily needs to be marked as an exhibit, but that the court accept document 223 as the report prepared by Dr. Seipel in this case.
Any objection, Mr. Fairley?
Your Honor, I have document 223, which is the report from Dr. Seipel dated July 17th of 2023, and it was filed on that same date.
Do you have any objection to my receipt?
I have no objection.
That'll be received into evidence. Go ahead, Mr. Lizay.
Dr. Seipel, I believe that you indicated that you had reviewed all of the other competency reports that were prepared in this case. Does that include a report that was recently authored by Dr. Litton, which called into question the defendant's competency in this case?
Yes.
And did you have an opportunity to thoroughly review that report?
Yes, I did.
And does your report outline some concerns that you have with Dr. Litton's report?
Yes, it does.
Ultimately, do you come to the same conclusion as Dr. Litton?
No, I reached the opposite conclusion with respect to the issue of competency.
That doctor, whatever his name is, I wonder if he was hired by the defense or something. I guess all these hired people, they just say whatever for the money. I mean, I don't know. It seems like that sometimes.
And what is your conclusion with respect to Ms. Schabusiness's competency in this matter?
So the opinion that I offer to a reasonable degree of professional certainty is that the defendant is presently competent to proceed.
And your report lists a number of reasons for that opinion, does it not?
It does.
And I would like to just sort of walk through some of those reasonings if we could. First of all, you address, I think, the issue of her background materials and I think the threshold question of whether or not she has a mental illness. I'd like to start with that supposition. What is your opinion with respect to whether or not Ms. Schabusiness currently suffers from a diagnosable mental illness?
I would object on foundation. I don't know if there are enough questions asked to render an opinion at this point. I object on foundation.
I think he has given a sufficient foundation. He listed all of the things that he did, including reviewing all of his records, conducting his own personal interview with her, and evaluating all of the available materials in this case.
Overrule the objection. Go ahead.
And so after reviewing the totality of those data sources, I noted that sometimes in the defendant's history, she perhaps has experienced clinically significant depression, has contemplated suicide, has had various behavioral issues, although I found no evidence to sustain an independent diagnosis of a severe mental illness, such as bipolar disorder, schizophrenia, or a like condition.
Actually, let me leave that alone.
With respect to the defendant's own reporting of having such a mental condition, what did you note?
I noted that there's been a remarkable inconsistency in the extent to which she has endorsed having a mental illness such as bipolar disorder, and instead on many occasions has ascribed any related or similar symptoms squarely to her abuse of intoxicants, most notably methamphetamine.
And did you also review information about her recent behaviors, whether that occurred in the jail or in court proceedings and things of that nature?
Yes, I did.
And what were your observations with respect to those recent behaviors and how they might impact a diagnosis of bipolar?
Yes, I noted that there certainly have been behavioral issues within the jail and in the courtroom, and I am certainly well aware of the assaultive behavior towards the previous defense attorney within the courtroom. I'm aware of the defendant throwing a chair at Dr. Litton. And while certain such behaviors certainly are disruptive and concerning, I found no evidence to suggest that there was a consistent pattern of such behaviors that could be directly attributed to symptoms of a mental illness. Rather, I am fundamentally unable to rule out that they're primarily volitional in nature.
In particular, let's deal with the issue of her throwing a chair at Dr. Litton. What concerned you about that particular incident in terms of your ability to assess whether that was related to mental health or volitional conduct?
So certainly if that were a pattern of behavior that was consistently occurring and seemed to be out of control, that could be an issue relative to competency and attending to and meaningfully participating in proceedings. Although again, it was an isolated event. It was noteworthy that after immediately, at least according to Dr. Litton's report, immediately after the defendant did such behavior, she calmly sat back down, which is inconsistent with someone in a state of psychotic agitation who typically would require significant external intervention or chemical or physical restraint in order to regain behavioral composure.
And did you note, behavioral concerns that occur at the jail?
Yes, there are intermittent acting out behaviors that do result in citations within the jail.
And did the nature of those citations, is that in your view consistent with a psychosis or consistent with volitional behavior?
I would say I cannot rule out that they're most fundamentally volitionally motivated, and perhaps by motives such as boredom as well.
And what is the basis for forming that conclusion?
Again, there's a lack of consistency both in the timing and type of these behaviors that were occurring. Again, they were very isolated, brief incidents. And again, other motives could reasonably be inferred, such as I'm aware that there was a day in which she stood nude when receiving her meal trays, and it could easily be inferred that exhibitionism or sexual gratification was a motive at play, and there was otherwise no evidence that she was actively symptomatic of a mental illness.
Ooh. Wow, so he's not buying the bullshit. Okay, he said it's volitional. I ain't buying the bullshit. You just a head for that guy high. Okay, you like that shit. You're crazy, but you ain't psychotically crazy or whatever they call that shit. We ain't buying it. Because I thought she kind of fit the bill for like some crazy mental whatever compared to like Letitia.
On the date that she exhibited such behavior.
We ain't buying the shit.
From your review of the jail records and from the other behavioral observations of Ms. Schabusiness, does it appear that she has any trouble controlling her behaviors when she has a need to get her own needs met?
Calls for objection. It calls for speculation, Your Honor. And it's kind of a compound question.
She's just like every other woman. No, I'm just kidding. I'm kidding. Chill, I'm kidding. We got a lot of women in the chat. I'm kidding.
Overruled. Answer the question if you can, Doctor.
And so I would say that based upon the information provided within the jail records, as well as my knowledge and contacts with the defendant, it does appear that she is able to maintain behavioral control when it is in her desire or interest to do so. For example, she displayed a sustained period of behavioral stability, which she herself directly attributed to her desire to have reduced security precautions within the jail.
And Dr. Seipel, you obviously mentioned you reviewed the report of Dr. Litton with respect to the contact that she had with Ms. Schabusiness and her observations in the course of her interview. Could you describe how your interview with Ms. Schabusiness differed from Dr. Litton's observations?
Yes, and so Ms. Schabusiness during now two contacts, and especially focusing on the most recent contact earlier this month, she maintained behavioral control. There was no acting out or aggressive behaviors. There were some moments in which her commentary waxed somewhat provocative, although she was easily redirected from such commentary, such that we sustained rational, reciprocal verbal communication about her recent adjustment within the jail, her clinical concerns, and various aspects of the pending case, such that I did not note any substantial deficits in her mental capacity to understand the proceedings or meaningfully aid in the defense.
And I want to talk particularly about that last point. You did in detail address with her understanding of the legal proceedings, is that right?
Yes.
And was she able to meaningfully describe the roles of the parties and the purpose of these proceedings and how they would go forward?
Yes.
Did she really express any concerns regarding any of those issues?
I would say there were some minor points of confusion, such as the maximum sentence for her lesser charges, or some of the nuances of the no contest plea, although she easily responded to brief education about those topics, such that in the end, there was no substantial deficits in her understanding of the proceedings in general, or the specific posture of this case, and the plea that she has selected for her defense.
And on the second point, the ability to assist in her defense, one of the concerns I think that Dr. Litton raised was proclaimed amnesia or inability to recall events. Is that something that you significantly noted in your interview with Ms. Schabusiness?
What was interesting was that across prior evaluations, she has claimed amnesia for past events, most specifically the date of her alleged misconduct in this case, although she did not make such a claim during our most recent contact. Rather, she relayed what seemed to be an intact recollection of the date in question and was able to comment coherently about different aspects of her experience and her mental status during that time frame.
And we talked about that in the video. She said she had amnesia, but she was very detailed about what happened.
One of the other issues that it appeared Dr. Litton relied upon strongly is this idea of both audio and visual hallucinations. Did you make any notation of that in your interview with her?
Yes, I noted that while there were some intermittent moments in which the defendant did claim to experience those symptoms, especially during the moments of the interview, I noted that to the extent that there's any legitimacy to those symptoms, they did not impair her ability to focus and communicate rationally with me, and the broader information available to me suggests that it is unlikely such symptoms are indeed legitimate.
And can you provide some detail on that, your concerns as to the legitimacy of those hallucinations and why you have those concerns?
Yes, my concerns are manifold, and I will detail them. There has been a remarkable inconsistency in the defendant's endorsement of symptoms across time. There has been discrepancy between what she has said to forensic evaluators and what she has said to clinicians within the jail in a similar time frame. She's been vague and unable to elaborate in those moments when she has endorsed symptoms. And moreover, outside of perhaps her contact with Dr. Litton, no one has conceptualized her as being preoccupied with internal stimuli across those clinical and forensic contexts. Moreover, on past psychological testing, there's been a significantly elevated probability revealed that she is feigning symptoms of mental illness, or at the very least is not a credible informant regarding the symptoms of her mental illness. And moreover, the visual hallucinations she has recently endorsed, specifically this supposed green train that plays Johnny Cash music. According to the forensic psychology and psychiatry literature, such symptoms are remarkably suspicious and not consistent with legitimate visual hallucinations.
And doctor, within your field, is there psychological or psychiatric testing that could be done in order to try to assess whether or not a patient is feigning symptoms?
Yes, there is.
And did you note whether or not Dr. Litton performed any of those such tests?
I did not find any indication in her report that she administered any form of psychological testing.
Is it unusual in your experience that someone would merely accept those claims without doing any such testing?
I would say in a forensic setting, in general, yes, it is unusual, but especially in a case of this stature and with this history that has called into question the legitimacy of her symptoms, to the extent that an opinion is predicated upon those symptoms, it would be against best practice for that opinion to not be supported by any form of psychometric data or analysis.
And in your review of the other evaluations that have been done of Ms. Schabusiness, did other evaluators perform such tests?
Yes, specifically Dr. Tracy Luchetta and Dr. Christina Angen both administered psychological testing to the defendant.
And were there concerns raised in the course of that psychological testing regarding the potential for feigning symptoms?
Yes, on both of those.
Feigning on some Letitia shit, maybe to the next level. This is like the hump we got to go through. We don't really have to go through, but I figured just to let everybody know that we're doing the trial Monday, just heads up, notification. Everybody have a lot of time in advance to know that we'll be streaming in real time Monday. If you didn't see the video I posted earlier, it's pinned in the chat. You can watch it after the stream. It'll give you a good synopsis of what happened, an idea of what happened, everything you need to know to start the trial with us on Monday. And this is basically, which they said it's happening Monday. People in the chat told me it's happening Monday. They're going through it again because they've been trying to slither out of this shit, trying to get out of this murder. That she crazy. She got some mental health. That's why I got the DSM-5 there, the Rolodex of mental health in the back. And they're talking about there's signs of feigning. I haven't heard malingering yet. This one, I like that word, malingering. I haven't heard that. I don't know if I've heard that yet. I feel like with the trials we've covered, we keep hearing malingering. So we'll see.
Concern was raised about the possibility of feigned psychiatric symptoms.
And that is consistent with your own observations of Ms. Schabusiness as well, correct?
Yes.
Maybe that's why she's been acting up in court, try to get out of this shit, Jury selections today.
And then, Doctor, again, just to reiterate, what is your conclusion with respect to Ms. Schabusiness's competency to proceed in this matter?
My conclusion, to a reasonable degree of professional certainty, is that Ms. Schabusiness is competent to proceed.
Thank you. I have no further questions at this time.
Amazing.
Cross-examination, Mr. Fraley.
Thank you very much, Your Honor. Dr. Seipel, good morning.
Good morning.
So you did a competency evaluation on my client, Taylor Denise Schabusiness, correct?
Yes.
And you met with her at the Brown County Jail on July 12th of 2023, correct?
Yes.
How long was that interview?
It was approximately 90 minutes.
And where did the interview occur?
It was in a conference room within the area of the jail that was immediately adjacent to the reception area.
And it was just you and Miss Schabusiness in the interview room?
There was also a postdoctoral forensic trainee with my practice who accompanied me and was a silent observer for the evaluation.
Was that the postdoctoral fellow, Dr. Steven Steinert?
Yes.
Was that typical practice to have another person like a fellow sit in on the evaluation with you and the defendant?
Yes, for training purposes, it is standard practice to have postdoctoral fellows accompany and observe evaluations.
Did Dr. Steinert ask any questions or engage in any conversation during the interview on July 12th?
No, he was entirely
I'm
silent.
gonna take off the captions on the screen, by the way, because YouTube has captions. So people that have captions turned on, you're getting double captions. I don't think it makes sense to have double captions. So if you want to see the captions, just turn it on YouTube.
Was Ms. Schabusiness handcuffed at the time?
Yes, she was.
And then she was also handcuffed to the floor?
Her handcuffs were secured to a waist belt and her ankle shackles were secured to a metal ring up on the floor.
Hell yeah, she shot.
So she could not get up or do anything, correct?
She could not rise from her seat, at least not fully, due to those restraints.
Damn right, she shot.
After July 12th, after your interview was done, after it was completed, did you go back to see her again or not?
I did not.
And basically, is it your understanding that as it relates to the issue of competency, the law, because you've been in the field, that a person is not responsible for criminal conduct if at the time of the conduct, as a result of mental disease or defect, the person lacked substantial capacity either to appreciate the wrongfulness of their conduct or conform their conduct to the requirements of the law. Is that correct?
Judge, I'm going to object at this point. That's the standard for NGI, not competency. So yes, at the time of the conduct, competency is her present sense.
Yes, I'll ask a different question.
All right, questions withdrawn.
You did address that issue though as well, correct?
The issue of NGI?
Yes.
No, I was not ordered to address that issue in this case.
Okay. As to the issue of competency, what were the elements for that you were looking for?
Yes, so evaluating a defendant's competency in the state of Wisconsin is guided by statute 971.13, which provides the legal standard that no person shall be tried, convicted, or sentenced for a commission of a crime so long as they would lack substantial capacity to understand the proceedings or meaningfully assist in their defense.
When you talked to, thank you, when you talked to Ms. Schabusiness on July 12th, did she have any difficulty understanding what you were talking about?
No.
Would you agree that she was not the best historian as far as providing detailed answers to you?
I would say that in terms of providing personal history, there was no substantial.
Hold up. Okay, thank you for the super chat, Mercedes. Thank you for the super chat, Deja Vu. Thank you for the super chat. If you guys could hit like, thank you for joining me today, Friday. I know people, you guys got, it's Friday, people, who knows, whatever, right? Deja Vu says the husband's Facebook post saying he's sticking by her? Nah, bullshit. Can we find the husband's Facebook? They're saying she's married. He's sticking by her? Damn, that's loyalty. Nah. No me diga. Nah. She was married. She was cheating with the guy. Hell nah. What's wrong with these guys, man? Damn. Thanks. Thank you for the super chat earlier. It says canceled. LMAO. And SW4x4. Thank you for the 5-month membership. It says call in Dr. Dorothy. Let's hand out DID diagnosis. Callie916. Thank you for the membership. Anonymous. Thank you for the membership. And we're caught up. Amazing. Nah. You ain't there for real, right? Let's get the mods. If the mods are in the chat, anybody in the chat, let's confirm this. They had an open marriage. Oh my God. Roll my eyes with that open marriage bullshit. I mean, people do that, but yeah, good luck to them, right? It's always funny too, because these open marriage people, kind of like Adam 22 and Lane of the Plug, they have like these rules and shit, which I find hilarious, right? And so like Adam 22, which I've heard of other couples having this type of thing too, where he's just like, all right, you can go there and, you know, have sex and do all this kind of stuff. Just don't kiss in the mouth. You know, I've heard some couples doing that. So don't kiss in the mouth. They can do all kinds of shit. Have the phallus in the mouth. I like that word too. Phallus. His phallus. I forgot what story I was covering. Like the phallus. All kinds of all whatever. Just don't kiss. Okay.
Sets in her memory functioning, her ability to convey.
And that guy with Adam 22, the guy that dogged out his wife, he's talking all kinds of shit on YouTube now, and Adam's pissed.
I would say
Post it on Discord.
Vagueness to her endorsement of clinical symptoms. That was not.
Yo, the simple 2023. Let's see. I mean, I don't know if Adam takes the or Cuck of 2023. I don't know if Adam takes the cake or this guy with Taylor. Let me see something. Nah, I don't believe this shit. Hold on, man. Taylor Schabusiness husband Warren jail. Hold on a second. Let's see. All right. Oh, this guy looks like a dude. He does. Can we confirm that he's sticking by his wife? Is this a Facebook post claims that Taylor and Warren have been dating since roughly 2017? Unfortunately, there's no data available. We cannot know. The Queen Taylor Schabusiness's husband's Facebook page reads, I do trust my beautiful wife. Hell no. I'll do anything to protect her. Stay strong, baby boo. I love you. Lord, bro, go out and get some. Jesus. What's wrong with you? Go pay for this shit. God damn. Maybe, you know, he's just hooked on her. Wow, so he's sticking by the wife. This chick was cheating on him and everything. Hell nah. He looked like a weirdo, though. So I can see the weirdness in him. Bro, Lord almighty. What is wrong with these people? I can't believe this. Wow, that's a damn shame, bro. And they got kids together, too, or what? What a fucking weirdo. Ah, man. She stood by him too. See, hold on. What is this picture from? I can't with these people, man. I shouldn't get pissed off. Oh, I'd be embarrassed. I wouldn't want to associate myself anymore with this lady. His jail pick? Well, he's locked up too, or he was locked up at some point. Maybe they have like a bond, a jail bond or something. Meth bond. Let's see, hold on. Okay, we got the Facebook. Wait, hold on. I don't know what's going to open up here. Let me take a look. He holding it down. Let's see, hold on. Warren Schabusiness. Let's check it out real quick and then we'll get back to this. Oh, Lord almighty. How do I get the full screen? Where's the full screen at? Oh, this is supposed to be full screen. Report me for what? My name is Warren E. Chabot, but I'm the one that blessed Taylor with the last name Schabusiness. Either way, I'm currently locked up on federal charges because I was framed. Anyways, I beat a conspiracy to distribute methamphetamine charge and pled to a possession with intent to deliver, which is the best deal I could get. So I was sentenced to 28 months because I already had 25 months in at the time of sentencing. With this being said, just know I'll be out by January 2024. So he's currently locked up, but possibly November or December this year. Amazing. For the person who said they're going to report me, well, good luck with that because my good time is my good time. Plus, in federal prison, I earn FSA credits, making my sentence even shorter. I could do whatever the fuck. Thank God for these liberals. So plan on Warren Schabusiness to be out soon. Now you know a little more about Warren. And trust me, come my release, there will be lots more to know about myself and my wife. Loyalty over everything. Wow. Wow. My wife might be locked up for a long time, if not life, but what the world... Hold on, let me see. But what the world... / community doesn't understand my release date is soon. Either way, my prayers go out to my wife, Taylor. She needs help mentally. Not according to this guy, the psychiatrist, the doctor. Brown County Jail and the Brown County Circuit Courts are failing at understanding this, nor do they even care. Yes, what she is being accused of is serious, but this doesn't change the fact that she still has rights and she still has family and people that love her. What about the guy she chopped up and the mom that found him in his head in a bucket? People that love her, no matter what her situation might be. Hopefully soon the court/jail will realize she needs help. People like to be nosy. I get that. People judge. You guys are judging a book by its cover. Shame on you. I get that too. It's what this world does and will continue to do. Either way, I stand behind my wife and I will forever stand behind her forever. I know what she's been accused of. It's not who she is. Not only has her addiction played a big role. I mean, you're over here being accused of being a supplier. Did you supply her with the shit? Just questioning. I'm wondering. But she does her mental. Okay, hold on. Let's see. I know what she is being accused of. It's not who she is. Not only has her addiction played a big role, but so does her mental background, as well as postpartum depression. So when does she have the baby? I just want my wife to know. I just want my wife to get help, professional help, because it's what she deserves. Like I said, my prayers goes out to my wife. I love her more than anything in this world, and this will never change, no matter what. Hashtag I love you, baby boo. Hashtag free Taylor Schabusiness. Hashtag free Warren Schabusiness. Hashtag Schabusiness Empire, no matter what. Wow. Lord help us.
Of itself suggestive of inability to provide detailed responses.
How did you start the interview off? Did you kind of have some small talk and then go into it, or can you tell me a little bit about that?
Yes, so every competency interview begins with an advisement of the evaluation purpose and the attendant limits to confidentiality associated with the professional contact.
I know there's some ladies out there watching like, damn, I wish I had a guy like that, like loyal, you know?
And then you started to kind of talk about some of the problems that she's had at the jail. Is that fair?
I'd say that not necessarily problems per se, but began with the discussion.
No way. Yo, Lily said, all right, I'm sorry, I got to pause this again. Like I said, once the trial starts, man, we're going to start finding little knickknacks and bits of information. Lily in London tagged me in this. Warren Schabusiness. Nothing anyone says can bother me. I'm still breathing with my head on, LOL. My wife, Taylor, might be locked up for a long time / forever, but that doesn't change the fact that she's my wife. I'm always going to stand behind her no matter what. F anyone who has anything to say about my empire, because right now, all that matters is my wife, okay? All I look forward to is making sure she gets the best lawyer and treatment she deserves. Shade gave her drugs, which caused all this. Who's Shade? Oh, you snitching? If drugs were never given to her, she would still be at home. But guess what? Life has took a turn for everyone. Now we all have to deal with this situation in our own way, which isn't good for anyone. Right now, I'm just finishing off these last 10 months. Then I'll be home to take care of my business. What business? Till then, the world can keep talking ish. Doesn't bother me anyway because I still have my wife. She's still breathing. While Taylor Schabusiness, keep her head up. Stay strong, stay positive, and continue praying. Never forget our bond is stronger than the world. In our empire, no one understands. Till it's too late to understand. Schabusiness way is the only way. All right, then. I love you, and I miss you so much, baby boo. Ride or die till death do us apart. What? Love always, Warren Schabusiness. Wow. I don't know if this guy's like just loving the attention. He loving the attention. Thanks, Lily. Lord almighty.
For functioning and adjustment within recent months, which naturally lends itself to discussion of various clinical issues, different events that have happened over the pendency of this case, and then proceeded into very direct and detailed discussion of various competency-related terms and topics.
You had a chance to review some Brown County jail records with regards to her stay there, correct? Her progress?
Yes.
You went through all the records, correct?
He could be trolling, yeah.
I reviewed records that were provided to me from the end of December of 2022 through July 6th of 2023.
You reviewed records that I sent to you, correct?
Yes, there were some additional incident reports from the jail that were sent to me after I had
Empire of Dirt.
report in for submission, and I did review those.
When you looked at the jail records, did you find that she had a lot of different issues in the jail on a daily basis with regards to not coming out of her room, not standing for jail count, other issues?
I would say the only issue that has been regular, though not necessarily daily, has been failing to stand for the required counts within the jail.
Okay. What about, was there an incident where she allegedly took a staple and jammed it into her arm where she needed to leave and get some medical care?
Yes, there was.
Can you tell me about that, what you reviewed as to that topic?
Yes, and so there were, and again, that was around the time that these records began in December of 2022. There was an incident in which she had inserted a staple into her skin, and then was sent out to the emergency department for treatment.
I have a couple of things to show you after this video.
That injury. And what is noteworthy was when discussing that during the clinical interview with Ms. Schabusiness, as she suggested that behavior was largely motivated by a desire for, as she called it, a change of scenery or to get some time away from the jail.
Do you know if when that happened, she was suicidal or in a psychotic state at that time?
And so she disclaimed to me experiencing suicidal intent at the time of that behavior, and immediately upon her return to the jail and discussing that incident with jail providers, she denied feeling suicidal and did not endorse or display any psychotic symptoms.
That incident where she put a staple in her arm, that was self-mutilating behavior, self-injurious behavior, correct?
I would say yes, it was a behavior.
So she did one staple or multiple staples? One staple ain't too hardcore. I mean, it's all right. I stapled my finger when I was a kid by accident.
For volition that resulted in an extent of a minor injury.
I remember how I did it.
During your contact with her, did you find her to be suffering from like a depressive disorder, from PTSD, from other issues?
I noted that she gives somewhat of mixed and conflicting information with regard to her recent emotional functioning, suggesting that on the one hand she was experiencing some depression, although perhaps on the other hand experiencing some modest mood elevation. Although during the moment of that contact she did not present as significantly depressed, she did not present with significantly elevated mood. Essentially there were no mood-related symptoms that impaired her ability to sustain focus and communicate coherently and rationally with me. With respect to the issue of post-traumatic stress, there does seem to be some symptoms of that kind in her clinical history, stemming from seemingly a history of abuse, although she's been inconsistent in the extent to which she has endorsed abuse. Although there was nothing that she endorsed or displayed that warranted an independent diagnosis of a condition like post-traumatic stress disorder.
Did Ms. Schabusiness indicate to you that her father had sexually abused her when she was younger?
Yes, that she did endorse experiencing that kind of abuse, that she conveyed that to me during the current clinical interview.
Same thing as Letitia, too, I think, right?
You also commented on the fact that her mother died, I believe maybe in 2008. Did you take that into consideration as as you reviewed her mental status?
I would say that is an aspect of her clinical history that I am aware of, although I did not note any direct impingement upon that historical event upon her current mental status.
I studied the jail records. There was an entry on or about June 19th of 2023 where Ms. Schabusiness apparently wrote on the jail wall with blood, "Happy birthday" for an officer or somebody. You remember seeing that?
Yes, I did find indication that she had written some letters upon the wall and filled in at least one of those letters with her own blood.
Does that?
Well, I mean, because I'm listening to this, I'm like, damn, that chick wrote "Happy birthday" in all blood. That's what this defense lawyer indicated. And so this guy, the doctor, clarifies, yeah, one of the letters, which is still crazy, but I thought she took a whole thing of blood and just like wiping the walls and stuff. Like, yes, the one letter, half a letter. Oh, he said one letter, but
filled in at least one of those letters.
Well, he said at least one of the letters.
Blood.
Does that give you pause when you assess her whole overall mental status?
I would say if there were more active indications of acute psychiatric instability, that event would give me more reason for concern, although given its isolated nature and the various performance strengths and psychiatric stability that she displayed during the clinical interview, no, it does not cause any substantial concern on my end.
Did you understand that Taylor Schabusiness was prescribed medications at the Brown County Jail, at least in 2023?
Yes, she has been treated with some psychotropic medications within the jail.
Like olanzapine, correct?
Yes.
And did you gather or garner information that she wasn't taking the meds, she refused to take the meds, that the meds got passed around, that she didn't actually...
Oh, so olanzapine is used to treat symptoms of schizophrenia, a mental illness that causes disturbed or unusual thinking loss. Okay. It's also used to treat bipolar. So, yeah.
ingest the medication so that she could get better?
There was indication, at least from her medication administration record, that she generally took that medication daily during the month of March of this year. I'm also aware that there was at least one incident in which a pill was discovered in the pocket of her uniform, which calls into question her medication compliance. Although since March, she has been remarkably inconsistent in accepting that medication, including taking it just a few times in recent months.
Is it fair to say, Dr. Seipel, with your training and experience, that if people don't take their psychotropic medications, then they can have a lot of mental health problems, and that can impact their understanding, memory, all of that, correct?
I would say to the extent that someone has an underlying mental illness, then yes, medication compliance could cause some issues with their mental status and relevant functional capacities.
You say yes if they got a mental health problem, unless they faking the funk. Yeah, it could affect them if they have an actual mental health problem.
You also reviewed, is it true that you reviewed some jail records where she was walking around naked during dinner service, standing naked in front of her jail cell window, and having issues with that, taking the clothes off, putting them back on?
Yes, there was one date in which it was noted that she stood nude at the window of her cell for passing of two of the meals during meal service.
Also, did you gather that she refused to stand for head count often when asked to do so?
Yes, and that would tend to happen in spurts. So there'd be several days in a row where she, and it was also noteworthy that it was often several other inmates on her pond, would all refuse to stand for count.
Did it say olanzapine or clonazepam? I thought I heard olanzapine. Clonazepam is Klonopin. That's a really strong, super strong. It's like for anxiety or for sleep or whatever. That's just like Xanax times 3, times 2 type of shit.
With regards to this case, her conclusions go to Dr. Diane Litton, PhD, her evaluation of Taylor Schabusiness, correct?
Yes.
Her conclusions and findings are in direct conflict with your...
No, you know what? I got that wrong. Clonazepam. I was thinking of Klonopin. Clonazepam is a psychiatric med. It's psychotic that helps restore the balance of natural substances, neurotransmitters in the brain. Okay. It can treat schizophrenia. I was thinking of... I don't know why I was thinking of Klonopin. Klonopin is something else. Clonidine. Klonopin. Is it Klonopin? Clonazepam. Okay, clonazepam, Klonopin. So I thought I heard olanzapine. I don't know.
Findings and conclusions. Is that fair?
Yes, we reached the opposite opinion with respect to the issue of competency.
And that's where the contest lies, correct? On the issue of competency?
Yes, as my understanding, that is what I have been ordered to evaluate in this case, and as my understanding, that is the purpose of this morning's hearing.
You had a chance to review Dr. Deborah Collins' report, correct?
Yes, I did.
You had a chance to review your earlier report, correct?
Yes.
You had a chance to review Dr. Tracy Lucetta's report from April 29th of 2022, correct?
Yes.
In Dr. Lucetta's report, do you know her?
I do not personally know Dr. Lucetta, although I've certainly seen her work on several occasions.
Okay, thank you. But you read over the report and you're aware of her findings, correct?
Yes.
Would you agree with me that she recommended a transfer of Ms. Schabusiness to one of the state's psychiatric facilities like Mendota Mental Health Institute or Winnebago Mental Health Institute for further evaluation under close and extended observation by qualified professionals? Are you aware of that?
Yes, that is the recommendation that she offered at the conclusion of her report.
Do you agree with that? That maybe the court should consider having Ms. Schabusiness go for a longer observation period with a team to assess her competency, rather than having a 90-minute interview or conference with the doctor?
Well, I would note, sir, that my examination findings were the product of substantially more data than just that 90-minute contact. It reflected review of extensive records that predated the charges being filed in this case, as well as extensive observations of the defendant over the entire pendency of this case. And as that provided sufficient information for me to reach an opinion to a reasonable degree of professional certainty, I do not believe that additional inpatient examination is warranted or necessary at this time.
Would you agree that this is a very complex case from a competency standpoint, from a mental health standpoint?
I guess I would not necessarily say that it is head and shoulders more complex than many other cases that I have handled in my career.
He said it's basic shit for him. It ain't nothing. Not really what he said. He just said it's not any more complex than any of the other cases it covers. Mental health cases. That shit basic.
You've only had your license since February of 2022. Is that fair?
Yes.
And would you agree that Dr. Litton, who is a PhD like you, has substantially more experience than you do? Fair?
I would say she's been practicing longer, although the extent to which her practice is focused on competency examination is unclear to me.
But you're aware that she did work at Mendota Mental Health in the past, correct?
I'm aware that she was employed at least one of the state psychiatric institutes, yes.
Did you look at her curriculum vitae at all?
Let's get dirty.
I guess I can briefly review it as it was attached to the PDF that also contained the report.
He said, "You brand new doctor. You just started this shit." That's you.
Would you agree that more data, more information could be obtained regarding Taylor Schabusiness if she went to Mendota or Winnebago for a 10-day, 30-day observation period? A lot more information could be obtained, correct?
I would say that yes, in a very general sense. Certainly, the one time being observed by the different professionals would provide additional data and observations.
Did you review the Bellin Health mental health records with regards to Taylor Schabusiness?
Yes, I did review treatment records from Bellin that you sent to me after my report was submitted pertaining to 2 episodes of care, one from 2012 and one from 2014.
I know that you indicated that you may consider preparing a supplemental report. You didn't do that with regards to the Bellin issue, Bellin records, correct?
Yes, for our correspondence, I advised that if upon reviewing those records, there was any information that altered the opinion offered in my report, that I would offer an addendum. And after reviewing those records, there was nothing that altered the opinion offered in my report, so there was no need to offer an addendum to that effect.
Okay, thank you. As to Ms. Schabusiness, she apparently received mental health services at Bellin Health here in Green Bay from approximately July 15th of 2012 to October 31st of 2014. Is that fair?
I noted that there were 2 separate inpatient admissions, one that was for 3 days in July of 2012 and the other that was for 3 days in October of 2014.
How many days in July of what date? You said July of 2012 and July of 2014?
It was July of 2012 and October of 2014.
How long was she at Bellin in October of 2014?
It was from October 28th to October 31st of 2014.
Was that inpatient admission?
Yes.
Okay. So she had 2 inpatient admissions at Bellin, correct?
Yes, from the records that I received, it reflected 2 inpatient psychiatric admissions.
And would you agree that she was admitted to Bellin Health Psychiatric Center as an adolescent because she had mental health issues, mental health problems?
I would say that yes, that in a broad sense, there were mental health issues and symptoms that seemed to prompt the presentation to those facilities.
Did you gain information that she was prescribed Lamictal, Wellbutrin XL, Abilify, Seroquel, medications of that sort?
Yes, those types of psychotropic medications, the records indicated, were provided to her within the facility.
That she was diagnosed with depression and attention deficit hyperactivity disorder?
Yes, those were historical diagnoses noted in her record, and she was also assigned a diagnosis across both of the inpatient admissions of a mood disorder not otherwise specified.
Thank you very much. And was it your understanding that as a youth she was expelled from school?
Yes, that is my understanding.
Can you explain the mood disorder? I'm looking at a report from Bellin Health that seems to indicate a diagnostic impression, Axis 1, mood disorder, not otherwise specified with prior history of psychosis. Could you expound on that a little bit for me?
Yes, and so from the information I gleaned from these records, it indicated that the admission in 2012 was prompted at least in part by an adverse reaction to the antidepressant medication sertraline. Sertraline is a selective serotonin reuptake inhibitor medication that in adolescence is widely known in some cases to cause paradoxical or adverse reactions, such as increased depression, increased suicidal ideation, and in some rare instances, it can induce psychotic symptoms. So the record suggested that it was not until beginning that medication that the defendant began to display psychotic symptoms, and those symptoms promptly resolved when that medication was discontinued within the hospital. So that would not be consistent with an emerging schizophrenia, but rather it was a time-limited and purely medication-induced psychotic episode.
Yeah, sometimes I get depressed too. In case they ever try to cancel it. Yeah, I sometimes get depressed.
Did you read in
Right?
some of the Bellin records that
What a life.
one of the major stressors in her life was the loss of her mother at such a young age?
Yes, that was clearly reflected in the records.
Well, the defense did good, at least by pulling out all this bed she was on.
When she was 16, she was voluntarily admitted to the crisis center for some suicidal ideation and being a runaway and not taking medications. Is that correct?
Yes, and she was admitted to an inpatient psychiatric unit after presenting initially to the crisis center.
And in the records also, did you gather information that Ms. Schabusiness had complaints of feeling things that were not real, almost like a dream, for several weeks, for 2 weeks or so, sometime in October of 2014?
Yes, I did read in the records that she endured experiences of that type in the time period leading up to her hospitalization.
And will you agree that she had a real hard time with the loss of her mother and cries about it quite often?
Yes, that again was reflected in the records that she continued to struggle to adjust in the wake of her mother's death.
And did you understand that Ms. Schabusiness had to go to school even on the day that her mom passed away?
To the extent that that was contained anywhere in the information I provided, that is not something that I took note of.
In school, she did terrible. She got all F's. Is that correct? Did you gather? I'm sorry. Did you gather that from going through the Bellin records?
Yes, it described how there was a decline in her academic performance during the school year following her mother's death.
Now, have you had cases where people that you work with in a professional capacity as a forensic psychologist, where people have court orders for civil commitment or court orders to take psychotropic medication?
Yes, that is certainly something that is commonplace across the state of Wisconsin.
Okay. And in this case, you did receive a copy of those orders, the order for commitment and the order for medications for Taylor Schabusiness?
I did not receive the court orders, although I received discharge documentation pertaining to the hospitalization during which she was assigned such a court order.
Okay. And an order for commitment, that means the person has a mental defect, is that correct?
The relevant legal standard primarily pertains to dangerousness. The person is in acute danger to oneself, others, or of serious property damage. It is not necessarily predicated per se upon any specific psychiatric diagnosis.
If I'm looking at an order for commitment and it talks about court finds the subject is mentally ill, and that says it for Taylor Schabusiness, would you believe that to be accurate?
I would say that, again, it is implicating some degree of mental health symptoms, although, again, it can be somewhat of parsing words, looking at is it legitimate mental illness per se versus aberrant mental status resulting from acute and insignificant ingestion of intoxicants.
And I'm looking at the order for commitment. The court finds number 4, the subject has been adjudicated pursuant to 18 USC United States Code 922 G4 as a mental defective or committed to a mental institution. Would you have any reason to doubt that?
So I wonder if you can clarify your question, sir.
Well, the order says that. So does that mean that she's got a mental defect?
I would say it means that someone involved in petitioning for that order apparently did believe that she did, yes.
And that from your review, was it your understanding that Taylor Schabusiness was committed for 6 months to Nicolay Psychiatric Center?
I'm aware that she was subject to a 6-month civil commitment that did not result in her placement within the facility for that duration, but rather discharged her with several conditions that, if not followed, could have potentially resulted in her return to a more restrictive setting.
And was your understanding that she worked with Brown County Human Services when she was at the Nicolay Treatment Center?
Yes.
And was it your understanding that the Nicolay Psychiatric Center is a maximum level of treatment? It's a locked unit. It's an inpatient facility. Is that correct?
Yes, it is a locked inpatient psychiatric unit.
So they don't just send anybody there. If you have a mental health problem, that's probably where you go, correct? At least in this town.
I would say if you're having an episode of aberrant mental status, regardless of the etiology, that yes, that it would commonly be a setting in which an individual would be placed.
If someone is deemed to be, to suffer from a mental defect or a mental illness, does that always tag along with them? Is that always a label that they have for the future going forward?
I would say certainly it's something that, to the extent it's contained within someone's file, that's a label that future evaluators and clinicians will see. Although, according to best practice, they would perform their own independent evaluation to determine whether they think that the individual continued to qualify for such a diagnosis.
And you don't often see people being ordered by the court to be required to involuntarily take medication and take treatment, correct?
I would say that the base rate for that it is certainly quite low, as again, part of the legal standard revolves around dangerousness, and it's a relatively high bar for someone to be determined to be in acute danger to themselves or others or significant property damage.
But was it your understanding, at least back in 2021 when Taylor Schabusiness was at Nicolay, that she was prohibited from possessing a firearm because of her commitment? Is that true?
Objection, Your Honor, just to the relevance of this.
Goes to the dangerousness that he just testified to.
Which is not at issue here.
I said what I said, so that's just my argument.
Yo, I said what I said. I can't lie though. Like this woman and my non-professional, just outside looking in, she kind of almost fits the bill for like mental health or whatever. I don't know. But of course, I don't know, there were two different doctors. One said that she is not mentally competent for the trial. Maybe there's a difference too about you can still have mental issues but still be competent type of shit, So maybe that's what we're talking about. It's not that maybe it's not an argument that she has had mental issues, but the argument is whether she's competent for trial or not, right? Cause she definitely. But then the whole thing, it's interesting how he said there's been faking the shit.
I'm going to sustain the objection. Move on, Mr. Freilich.
All right. The fact that she was under a civil commitment order and a order to take psychotropic medications, that's a very serious consideration that a psychologist has to take into account when assessing the competency issues, correct?
I would say that certainly is an important piece of a defendant's clinical history that is taken into consideration, although it does not necessarily directly translate on the issue of her contemporary mental status, especially given that at the time of her admission to that facility, she had been using methamphetamine several times per day for several months leading up to it, which could easily explain the apparent mental status at that time, and presumably is not a factor given her restricted access to intoxicants within the jail at present.
You know, as a psychologist, you have a PhD degree, you have a lot of education, a lot of experience with your 800 competency evaluations that you've done. You look at records, correct? And you've looked at the Bellin records for Taylor Schabusiness, correct?
Yes.
And at least as to the diagnosis for her from Bellin, is it true that at least in 2021 they diagnosed her with bipolar disorder, current episode, manic severe with psychotic features? You remember reading that?
Yes, I am aware that that diagnosis was assigned when she was hospitalized in 2021.
Oh. And that she was even treated with medications like Aristata and Prosecution, correct?
Yes.
And I looked at did you look at the Brown County Human Services Community Treatment records, which I believe are part of the Nicolay records? You looked at those records, correct?
I reviewed the records that pertains to the inpatient hospitalization. So to the extent that there were any peripheral records that did not directly pertain to that episode of care, I cannot necessarily say that I reviewed them.
It's true that she was at Nicolay, they say Brown County, but she was at Nicolay from March 22nd of 2021 to April 12th of 2021, correct?
Yes.
And in the records, it says, quote, this patient was on the psychiatric unit at Brown County from 3/22/21 to 4/12/21. She has a diagnosis of bipolar disorder and presented extremely psychotic and manic. And then it talks about her situation was complicated by methamphetamine use and also by the fact that she was pregnant, correct?
Yes, I'm aware that those were the impressions and the information contained within those records.
Do you agree with the fact that she was diagnosed with being bipolar?
I agree that that diagnosis was assigned to her as reflected in the records, although providing a diagnosis of bipolar disorder to someone who had very acutely been abusing numerous intoxicants is not best practice, as a bipolar disorder, by definition and by diagnostic criteria, cannot be most fundamentally attributable to the effects of a medical condition or an ingested substance. And so from my perspective, I don't see how those providers could have determined the presence of an independent mental illness separate from the very significant polysubstance abuse that continued up until the day of her admission to the facility.
So it's your opinion, you don't think she's got bipolar disorder, correct?
It is my opinion that the totality of information available to me weighs contrary to that diagnosis.
But do you know for sure if she has bipolar or not?
I would say to a reasonable degree of professional certainty, she does not meet diagnostic criteria for bipolar disorder.
Who diagnoses that? Is that the purview of a psychologist or a psychiatrist?
I would say either of those disciplines would be trained and equipped to assign such a diagnosis.
In this case, well, for a psychologist, there's 2 gold standard tests, correct?
I would say that certainly there are tests that are more widely used than others. Some people will apply the label of gold standard, although it's not as if there's a list I can consult that differentiates gold standard from non-gold standard tests, psychological tests.
The main widely known test is the MMPI Minnesota Multiphasic Personality Inventory. Is that correct?
I would say that yes, that is the most widely used objective measure of adult psychopathology and personality.
And then the other test is the Milan Clinical Multi-Axial Inventory, is that correct?
Yes, that certainly is almost as widely used as the MMPI for the same purposes, and primarily it is used specifically to tease apart different personality disorder diagnoses. That is an advantage that it carries over the MMPI.
You can get a lot of data as a psychologist by performing these two tests on a patient or an individual, correct?
It certainly can yield relevant information, yes.
Did you administer these two tests to Taylor Schabusiness when you met with her earlier this year or on July 12th of 2023?
I did not.
Okay. And yet you criticize Dr. Litton for not doing that as well, correct?
I criticized her for not performing more symptom validity testing, which is something that is embedded within an instrument such as MMPI, although there are also separate instruments that are much briefer that can be used for the same purpose.
And I think you said that Dr. Engine and Dr. Lucetta did the MMPI and the MCMI, is that correct?
So Dr. Engen administered the MMPI and Dr. Lucetta administered a competency-specific instrument, the evaluation of competency to stand trial. I believe there's the revised edition. And so within that, it contains subscales looking at the probability that an evaluation subject is feigning both psychotic and non-psychotic symptoms towards feigning adjudicated incompetency.
More information could be gathered about Ms. Schabusiness's mental health profile and status as it relates to competency if she went inpatient for a period of time at Mendota or Winnebago. Is that fair?
I object that this has been asked and answered already.
No, it hasn't, because it relates to the MMPI and the MCMI. I can rephrase, Your Honor. Maybe I should do that.
You're a little savage there. No, it hasn't. I said what I said. Oh, shit. Okay.
All right, well, maybe you should. And you will, the question is withdrawn. Ask another question.
Okay, thank you very much. As it relates to the MMPI and MCMI, if Ms. Schabusiness was sent to or transferred to Winnebago or Mendota, more data, more information could be garnered as it relates to this competency issue. Is that fair?
I would say that the repeated administration of those instruments could yield additional clinical data, although again, there was sufficient data for me to yield an opinion to a reasonable degree of professional certainty regarding her competency. So I really have no reason to believe that there would be much competency-specific data that would be yielded by such instruments.
But the issue as it relates to competency, as far as the doctors, the psychologists are concerned, it's kind of fractured because people have different opinions. Is that fair? The professionals have different opinions?
I would say that, yes, certainly in terms of recently that myself and Dr. Litton have reached diverging opinions regarding the defendant's competency.
Did you also understand that Taylor Schabusiness was admitted as an EM1 petition for auditory hallucinations and tactile hallucinations, such as being punched in the face and stomach and other delusional behavior? Was that your understanding that that happened?
It is my understanding that such symptoms were endorsed upon her admission to the Nicolay Psychiatric Center. Again, I would note that that occurred following a prolonged period of heavy methamphetamine use.
A lot of drugs. That's what he's saying.
And she was at least telling staff at Brown County that she was seeing the staff's hair fly all around, that she was hearing voices and seeing things like small rabbits and feeling as though a magnet was keeping her in her chair. That was in the reports as well, correct?
Yes, the records reflect that she did endorse such symptoms at that time.
And she indicated that all she wanted to do was just go to heaven, correct? That was in the reports.
Yes, there were certain comments to that and other effect, generally pertaining to thoughts about death and or suicide.
And did she also indicate that she couldn't think of what was going on in her head and that her thoughts were disorganized?
From my recollection of the records, yes, she endorsed cognitive symptoms of that kind during that treatment episode.
Did it indicate, at least now I'm going to focus on your report. Did it indicate in your report on page 3 that you talked about there was some difficulty or impossibility in parsing out to what extent she got improvement from taking medications, psychotropic medications, versus forced abstinence from intoxicants?
Yes, I noted that that was, again, a point of confounding information with regard to her diagnosis.
And that she had a pretty significant history of polysubstance abuse, correct?
Yes.
She abused marijuana, hallucinogens, cocaine, opiates, methamphetamine, heroin, fentanyl, correct?
Yes.
And that she had aberrant mental status and sometimes a tendency to rampage, is that right?
Yes, and she specifically attributed that rampaging tendency to acute methamphetamine intoxication.
Did she ever tell you that, well, strike that. When you met with her on July 12th of 2023 for 90 minutes, did you see her smile at times where you wouldn't smile? Did you see her laughing inappropriately? Did you see unusual, bizarre, weird behavior?
I would say that yes, that the grinning out of context and some brief moments of inappropriate laughter were noted. I would not classify them as bizarre in this instance, and they did not detract from us having irrational reciprocal exchange.
But she would smile out of context to a evaluation topic, correct?
In some isolated moments, yes.
Did you see any evidence of psychosis at all during your contacts with her on either occasion when you met with her?
I did not.
You did a report to the court on November 18th of 2022, correct? Competency evaluation?
Yes.
And then in there you indicated, page 5 of your report, that you indicated, in effect, her current endorsement of psychiatric symptoms appears illegitimate or, at the very least, exaggerated, correct?
Yes, that is what I wrote in that document.
So is it fair to say that you don't know if she is suffering from some kind of a mental disorder, or if it's feigning or faking? You can't say 100% what it is, correct?
I would say, again, to the totality of available information that is available to me at this time, to a reasonable degree of professional certainty, I can say that there is no credible evidence of her laboring with a severe mental illness, such as bipolar disorder or schizophrenia, which are typically the types of psychiatric conditions that would in and of themselves have the potential to render someone incompetent to proceed.
Did you ever see her distracted by internal or external stimuli of a delusional or psychotic nature during either interview that you had with her?
I would say during the November 2022 interview, there was no evidence whatsoever of any distraction. During the current interview, there was a moment in which she quite forcibly presented herself as if she was seeing the green train within the room, a symptom which, again, I find no credence or ability to believe, but even to the extent that I would indulge that it did occur, I promptly redirected her, and there was no further apparent issue with such a green train. So again, to the extent that symptom was legitimate, it was a one-time instance, easily redirected, and had no impingement upon her rational participation.
During your interview with her on July 12th of 2023, did you see her get off the chair, sit on the floor, kneel down, turn her back to you, or anything like that?
She remained seated. There was no restlessness. There was no attempts to substantially shift her posture. She remained seated, facing towards me, and engaged in our discussion.
When you met with her, did she ever say that she heard voices at all?
She made a vague reference to hearing screams that sometimes come from other inmates within the jail. Other times she believes they're originating from within her own head. Did she indicate that she was suffering from nightmares at all since being at the jail? I do believe she made some reference to intermittent experiences of nightmares, yes. Okay, I have no other questions. Thank you.
Can you redirect Mr. Lizette?
Just very briefly, Your Honor. I think early on in the cross-examination, you were asked a question about having a postdoctoral fellow accompany you in the interview. Is that correct?
Yes.
You were asked about the appropriateness of having someone else present during an interview. Did you note in Dr. Litton's interview whether anyone else was present?
Yes, according to that document, it suggests that defense counsel was present for the entirety of that evaluation.
Based on your experience, is that consistent with best practice?
I would say that is a highly atypical arrangement for a forensic mental health evaluation.
And why is that?
And so when I say a third party, I don't mean a silent observer that was there for training purposes, as I have no reason to believe that my postdoctoral fellow being present had any influence on the interview. And when I say a third party, I mean someone with some form of other pre-existing relationship with the defendant, whether that's an attorney, a relative, or whoever it might be. It is fundamentally impossible to parse out to what extent that person's presence and or influence might have influenced the evaluation subject's performance or the content of their responses.
In fact, from your review of Dr. Litton's report, does it appear that Mr. Freilich was actually asked at some point during the interview to participate?
I'm going to object to the form of that question, Your Honor. It's in her report. One question was asked. I didn't ask to be there, but the problem was that the chair got...
Mr. Freilich testifying? He's not been sworn as a witness.
The objection.
Relevance.
Overruled. Do you have the question, Doctor?
If it could please be repeated.
Just asked, I think, whether or not from Dr. Litton's report you were able to observe whether or not Mr. Freilich was actually asked to participate at a point during the interview.
Yes, it did appear from my reading of that report that during the interview he was asked directly about his impressions of the defendant's competency.
And that was done in front of the defendant?
Again, according to my reading of the report, it does seem that it was done in the room while the defendant was still present.
You were asked a question about medication noncompliance and whether that might have an impact on someone's mental state. Did you observe in the jail records from the recent time period, end of 2022 to present, whether or not Ms. Schabusiness had been compliant with taking any mental health related medications?
So since the end of March 2023, she has been remarkably inconsistent in accepting olanzapine, which is her prescribed psychotropic medication.
And based on your review of those jail records and your conversations with Ms. Schabusiness, has her non-compliance with medication appeared to significantly impact her functioning?
I did not notice any appreciable change in the records provided to me in her mental status or behavior that would seem to derive from her becoming non-compliant with medications.
So whether she take the meds or not, she's the same. Oh,
really, her baseline behavior remained unchanged even after those medications were discontinued.
And is that significant to your analysis that when she's not taking medication, her behaviors don't appear to get any worse?
I would say certainly it suggests that, one, it's a point of data that weighs contrary to the presence of a legitimate severe mental illness, which typically, if someone were to become non-compliant with medications, there would be a noticeable exacerbation in symptoms. So from that clinical perspective, it is relevant, but also from the forensic perspective, it suggests that medication non-compliance really is a peripheral issue to her competency, and that her baseline knowledge and functional capacities appear to remain constant, regardless of whether she is or is not taking psychotropic medication within the jail.
Then, Doctor, you were asked extensively about the stay in Nicolay in 2021, where she, I think it was March of 2021, where she arrived. That was about a 21-day stay, is that correct?
Yes, I noted that it was approximately 3 weeks.
And it was indicated both in the notes and through other information that's available that Ms. Schabusiness had significant methamphetamine use prior to that hospitalization?
Yes.
And did you note a significant change in her behavior from the first part of that stay upon arrival and to her behaviors at time of departure from the facility?
Yes, a linear trend towards psychiatric stability was noted across
She was like
3
40.
weeks, such that
40
the
something.
seemingly psychotic symptoms had cleared and her thinking and behavior became more organized, and she was no longer viewed as an imminent risk of harm to herself or others.
So essentially within a relatively short time frame when the methamphetamine was no longer in her body, we're noting a very significant improvement in symptoms.
Yes.
I have no further questions.
On those topics, Mr. Freilich?
I have nothing further.
Okay, then the question is, I suppose, is whether Dr. Seipel is going to be excused or whether anyone might want to potentially call him as rebuttal testimony to the rebuttal testimony that we may be hearing. I'll start with the state. Do you want him released, or do you want to have him stay on the line?
I think he can be released, Your Honor.
Any objection to him being released?
I have no objection to that.
Dr. Seipel, your participation is concluded. Thank you very much.
You're very welcome, sir.
Any other witnesses you want to call, Mr. Lizay?
Not from the state, Your Honor.
Mr. Freilich?
Your Honor, I'm going to need a little bit of time to talk to Dr. Litton on the issue of whether she's going to testify on rebuttal. We talked about that last night.
Okay, we'll take it. The court will then take a recess for 10 minutes. It is now it'll be a little more than 10 minutes. It's now quarter to 10. We'll reconvene at 5 minutes to 10. All right?
Okay.
We are in recess.
Check out this video real quick. I saw Tatum posted this. YouTuber pulls epic prank at WNBA. Oh, hold on. Let's see her walking out. She's making any facial gestures. That's sweetie.
I know.
I just yeah, sit down. Yeah, sure. Have a seat. No,
I'm gonna go call Diane. Okay.
How's she supposed to? I guess she can use her hands. But how's she gonna do it? His hands tied to her waist, no? Is he gonna have to feed her the water? Like, hold it up to her, or she can drink it still? Or she can drink it. I want to observe how she drinks. Oh, like a person? Just like a regular person? I don't know if maybe she should like stick her tongue out and start slurping it up or something. Or, oh, she just sips it like a regular person? Okay. Oh, hold on. Oh, okay. I thought she was gonna do like some crazy shit, like a dog or just slurping the shit up like a cat or something. Got a little smirk on her face.
I just scared.
Would have been gangster. She like look at the camera and say,
17 at 2 p.m.
all right, I guess she drinks like everybody else. All right, so let's check this shit out real quick. YouTuber pulls prank, epic sleeping prank at the women's NBA.
Score foul, 0. She is nurse.
Help me out so I don't have to escort you out, sir. Thank you.
Okay. I'm sleeping.
You didn't pay for those.
I did pay for them though.
Not all of them.
I did. I bought 4.
Homeboy tripping.
Hell no, man. I thought she was like, do some crazy shit with the cup. That would have been, somebody needed to advise her if she was trying to get me crazy for the trial. All right, let's skip ahead. Let's see. Man, what's going on? She's doing all the little. I don't know if they gotta bring the other doctor. Oh, they need Dorothy Lewis. Yeah. Dorothy.
You're up, Dr. Litton. Had an extended conversation with her last evening and this morning after we took our break. I need 1 minute.
My friend went to jail for the murder of his mom. He did 10 years. That's it? Wow. He was a schizophrenic and victim of SA. Oh, he had a psychotic break but still went to jail. He took accountability and time. Oh, okay, wow. Damn.
Your Honor, after much thought and discussion with Dr. Litton and with my client agrees with this, that we're not going to call her in rebuttal. We're going to leave the record as it is.
Okay, then, unless I'm mistaken, I'm going to excuse her.
Yes, she can be excused.
Mr. Freilich,
Yes, she can be there, Your Honor.
any reason, Mr. Lizzie, why I wouldn't excuse Dr. Litton?
No.
Dr. Litton, you are excused. Thank you very much for your time.
They didn't bring the doctor to try to find it again.
Okay, then I will turn to the state for an argument. Mr. Lizzie.
Thank you, Your Honor. As the court is aware, it is the state's burden at this juncture to demonstrate by the greater weight of credible evidence. So it is a relatively low burden, but it is the state's burden to demonstrate that Ms. Schabusiness is competent to proceed in this matter. I think when the court considers the totality of all the information before it, that it's quite clear that Ms. Schabusiness is in fact competent to proceed in this case. And this is a judicial decision. It's not a medical decision. It's a decision that the court can make based on a variety of different factors. We've now had 5 different competency evaluations in this case. Dr. Litton's evaluation is frankly the only evaluation that suggests that she's not competent. I think there are a number of flaws with Dr. Litton's evaluation, and I think that Dr. Seipel's report and his testimony here today call into question a number of her findings and certainly the methodology that was used today. And I do just want to take a moment that when I asked the question about Mr. Freilich being present, I certainly was not intending to suggest that Mr. Freilich did anything inappropriate at all. That was not the purpose of my question. I think to the extent that Dr. Litton had someone else in the room, that's a decision she made that may not be consistent with best practice. But I don't want to suggest that Mr. Freilich made any attempt to try to influence competency.
On some Dorothy shit? On some Dorothy Lewis shit?
I do think that what clearly makes the most sense is.
What was he saying? The attorney was in there during the whatever the examination? Is that whoever that is?
Dr. Seipel's ultimate conclusion in this case, which is that to the extent that there are any potential symptoms of psychosis in this case, that those symptoms had generally been driven by 2 things: intentional use of illicit substances, particularly methamphetamine, and then volitional conduct, frankly, on the part of Ms. Schabusiness. And of course, as the court is to consider, it isn't just does she have a mental illness, does she potentially have some sort of symptoms that may in some way make it more difficult or more challenging for her to participate. The issue is, do those symptoms, if they exist, do they substantially impact her ability to understand what's going on and to assist in her defense? And I think quite clearly neither of those things are present. Frankly, I'm not sure that even the motion from counsel suggests that there has been a significant impact in his ability to work with Ms. Schabusiness on this case as a result of any of those perceived symptoms. And in the interviews that she's had with all of the clinicians, she appears to generally understand the concepts, the legal concepts. She knows who her attorneys are, what the role is. She knows what the state's role is. She knows what the court's role is. She understands what she's facing, why she's here. And she is able to pretty substantially describe the facts that put her in this position. And the court is able to consider all of the facts and circumstances that are available and its own observations of the defendant at counsel table, of her ability to sit through lengthy, complex motion hearings without disruption, and apparently to assist her attorney throughout that process, and Mr. Freilich's ability to communicate with her quite well. It does appear that she and Mr. Freilich have developed a quality working relationship and that she's able to assist him in this process. I think when the court evaluates all of those factors, that it's quite clear that the state has met the burden by the greater weight of credible evidence that Ms. Schabusiness is competent to proceed in this action.
Okay, thank you. Mr. Freilich.
Thank you, Your Honor. The law, Wisconsin law 971.14 subsection 3 of the Wisconsin statutes indicates that no person who lacks substantial mental capacity or understanding of the procedures to assist in her own defense may be tried, convicted, or sentenced for the commission of an offense so long as the incapacity endures. We have a young lady here, Taylor Denise Schabusiness, who does have mental health problems. She's been at Bellin Psychiatric Center for mental health treatment. They said that she had bipolar disorder with psychotic features. She's been to the Nicolay Psychiatric Center for a commitment, 6-month commitment order. She was there for about a month, but she was under a court order for commitment that was filed April 1st of 2021, and that she was deemed to be mentally ill. She was deemed by the court to be adjudicated as a mental defective or committed to a mental institution. She was at the mental health institution, and that she was under a court order to take psychotropic medications. So she has a history here of lots of problems. The Brown County jail records bore out that she's had problems with following directions, standing for head count, drawing on the walls.
Standing for head count. She's problematic. She doesn't want to stand still when we're doing a head count.
Doing all kinds of bizarre and odd behaviors. And what we have here are two diabolically opposed conclusions or opinions from the psychologist here. Dr. Seipel feels that Taylor Schabusiness is competent, and our doctor, Dr. Lighton, who has a lot of experience, she opines or concludes that she's not competent. So we have a problem here. We have we're at a crossroads. We've got some issues that have to be sorted out. I beg to differ with Dr. Seipel. I mean, he testified that this is not a complex case. It sure is a complex case. There's lots of records. There's lots of history here of mental health problems.
Y'all want to see some crazy shit? Who tagged me in this? Gravity, thank you. Bro, this is some Miami shit. Y'all want to see something real crazy? It's 40 seconds. This is how we do chases here in Florida. I was saying playing. Let me give you the synopsis real quick. Statement from Miami PD yesterday at 1:25 p.m. An officer attempted to conduct a traffic stop on a blue Charger at the intersection of Southwest 2nd and 7th Street for a traffic violation. As the officer approached the offending vehicle, the driver placed his gear in reverse. Let me pause that. In reverse, nearly striking one of our officers, ultimately crashing his vehicle into our Mark City police vehicle before fleeing the scene towards I-95. Investigation is still ongoing. Check this shit out, bro.
Ay, el policía lo jodió.
La policía. Ay, mi madre. Ay.
Ah, el tipo allá adelante lo bloqueó.
Piri, piri, bamba. Oh. Oh, push that shit on. You're pushing it. What? I mean, playing. Who's California Council? We don't gotta be. Let's give him our safe space. Yes. Let's do a little pepper ball, a little taser. Well, nothing wrong with the taser, but boom, punching us. Look at this. Yo, he punched this shit with his bare hand. What? I don't know who this guy is, but he threw the car in reverse He pulls his gun out, or I don't know if that's a taser or a gun. He didn't shoot it though. Peels out. Wow. Look at this crazy motherfucker. 95? Wow. Hey! Se fue. Pura boom para beat. Wow, bro. How crazy is that?
Drug addiction issues, all different kinds of problems. I think that both of the doctors have a lot of information, have a lot of training. They've looked at all these reports that have been submitted to the court. But Dr. Tracy Lucetta, who's also a PhD, she sent in a report that was filed on May 6th of 2022 when my predecessor, Attorney Jolly, was on the case. And she indicated that she recommended that my client be transferred to one of the state's psychiatric facilities like the Mendota Mental Health Institute or Winnebago Mental Health Institute for further evaluation under close and extended observation by qualified professionals. If she was sent to a state facility like that for a week or a month or whatever time is needed, a whole team
really
of professionals could assess, fully assess my client's competency to proceed in this case. There are all kinds of issues here that have to be sorted out. It's not a clear-cut case, in our opinion. And I would argue that, a 90-minute interview by Dr. Seipel with Ms. Schabusiness, I don't think that is going to be able to be enough time to really fully understand and address the issues in this particular.
Happy birthday, Lexa!
Dr. Seipel didn't do the MMPI or the MCMI. Dr. Lighton did not. Dr. Engine apparently did. I also want to comment on the issue with Dr. Lighton. She asked me to sit in, and I know that there were concerns.
He pulling some Letitia Dorothy shit. Coach, you coaching the psychiatrist or something? You giving notes and shit?
Because the chair was thrown at her, and she's an older lady, and so I sat in.
Oh, okay. So you did it for her safety. They couldn't get security or nothing like that. They had to have the attorney sit in with the psychiatrist. Okay.
That's what happened there. I didn't get involved. I stayed out of it.
Yeah, bullshit.
But I was just there for, I think my client felt more
I'm sure it's probably recorded.
comfortable with that. So I just want to comment on that. But I believe that my client is not a very good historian. I think she's got memory deficits. We've got all these records that I've poured over and looked at, sent to the court. I think that my client has had or does suffer from bipolar 1 disorder based on my review.
There was a historian that day when she was talking to the cops about chopping this guy's head off and what she did for 2 or 3 hours to his body after he's dead and the toys that she used on him. There's a good historian then.
And, based on her conduct with regards to throwing a chair at the professional that's trying to evaluate her, attacking her, Mr. Jolly, allegedly previously in court, engaging in other courtroom antics, the staple going into her arm, not taking medications,
Staple.
Who knows? Who knows if the drugs, the methamphetamine, the marijuana, the cocaine, all these other drugs, did they cause brain damage? Did they cause a mental defect? That's
I
all
guess
for
she was doing. They had her on a lot of meds when she was younger.
the court to decide, but I submit that it likely did, and it's caused a lot of different problems for Ms. Schabusiness with being able to really participate, understand what's going on, assist in her own defense. The fact that she apparently did have some hallucinations in the past, I think all that leads to the conclusion in my argument that my client should be deemed not competent at this time, or if the court doesn't feel they can even make a decision on that, send her over to Mendota or Winnebago for further evaluation. Then we'll know. Then we'll know for sure if she's ready to participate in a trial and assist with
defense on her head. Yes, church.
counsel and be able to understand what's going on. I have some serious reservations on her mental status, especially in light of the civil commitment, especially in light of the order to take medications. She has been deemed mentally ill by a court of law, so nobody can dispute that. I would submit that that's likely continuing, but there's all kinds of different opinions here. So I'd ask that the court go along with my arguments that she be transferred to one of the state's facilities for further and extended observation. Thank you.
Thank you, Mr. Freilich. Well, I've had an opportunity now to listen to the testimony.
I'm working on the merch site,
the
Ozzy.
evaluators.
Had some
I've
issues
also
with
had an
Google. Trying to
opportunity
fix it.
to review
I want to
both of the
revamp
reports.
everything on the website.
I've had an opportunity to observe and weigh their credibility as they've been testifying and observe their testimony. And frankly, as has been alluded to here by the parties, I've had an opportunity just from the time that we've been in court over the recent past to observe Ms. Schabusiness and how she's participated in this case. And on several occasions in the past when we've addressed this issue, I've had I've reviewed the history, and I'm not going to review the history of the competency process that's gone through here in this case again, because I've done it several times. But I want to highlight a few things, and that is that on 3 separate occasions, this court has ordered, has tasked the Wisconsin Forensic Unit with assessing Ms. Schabusiness' competency. And I know there's been other evaluations that have been conducted as well. But in the first one, Dr. Collins really cautioned the court to maintain vigilance on this issue throughout the case. And I have done that. I have done that. And I've listened to the request for on various occasions to have more competency evaluations conducted. On a few of those occasions, I've denied that request. And then this time I granted it because Dr. Lighton came forward. Really, each of these evaluators has a different opinion. Dr. Lighton's opinion on page 2 of her report is, quote, "My opinion also is that to a reasonable degree of psychological certainty, Ms. Schabusiness is not competent to proceed to trial," close quote. Dr. Seipel, as he testified here today, has an opinion directly to the contrary. His report indicates, quote, "The weight of the credible information again points to the conclusion that Ms. Schabusiness is competent to proceed, and I offer that opinion to a reasonable degree of professional certainty to the courts for the court's adjudication," close quote. In analyzing not only their testimony but the reports, I parsed through the reports, and frankly, it's actually difficult to parse out and unwrap Dr. Lighton's report regarding which piece relates to the NGI and which piece relates to the competency. Some things I want to just address regarding Dr. Seipel's report that I find meaningful, that I find insightful to me. I'm going to read a couple of those things.
Okay,
on page 14 of a report, he addresses his interaction with Ms. Schabusiness, and I think it's very relevant. He says, quote, "Her commentary occasionally waxed somewhat provocative, for example, sexual or otherwise graphic. However, such comments were not directed at me in any form of threatening or solicitous manner. Rather, she simply seemed to be fishing for a reaction. Thus, I either ignored such comments or matter-of-factly acknowledged them before continuing with my line of questioning. Through such an approach, I was easily able to sustain Ms. Schabusiness in rational, reciprocal, forward-moving discussion."
So he trying to get a reaction on it by saying provocative shit, and I guess he was, I don't know if stoic might be the thing, but yeah, non-reactionary, and she's trying to get a reaction out of him.
Her replies were almost...
Dorothy would have been like, "Oh my God, whoa!" But he just kind of kept his composure, I guess. All right, next.
...always relevant, albeit not always forthright, and she was easily redirected and responsive to prompting when needed. Moreover, in the few moments where she was evidently confused by questions, she easily benefited from simple accommodations such as repetition and rephrasing. Her expressed thoughts were consistently organized. I detected no credible delusional beliefs, finding claims such as that she believed Dr. Lighton to have stuck her tongue out at her to be entirely lacking in credence. I found that relevant. It was a direct reflection of what the doctor experienced when he was interacting with Ms. Schabusiness. In another portion of his report, he notes, "In any event, there was no evidence whatsoever of Ms. Schabusiness being distracted by any form of hallucinatory phenomenon." That's on page 15 of his report. Just summing some of the highlights that were also gleaned during the testimony.
Tisha Jr.
Page 16 of his report, he notes that Ms. Schabusiness indicated that she can assist her attorney in her defense by giving him all the information possible. Thus, she offered that it is important to be forthcoming with defense counsel. So he's able to help me. He can't if I don't be honest. Indeed, she stated that she has been honest with Attorney Freilich about the circumstances of this case. The report goes on in another location to indicate, quote, "When considered in that light, there simply is no reasonable basis on which to conclude that Ms. Schabusiness lacks capacity to behave appropriately and communicate rationally, given that she has now twice clearly displayed such capacities." He goes on to indicate, quote, She has no difficulty grasping the roles of relevant courtroom personnel and the adversarial nature of the criminal proceedings. Again, I found all of those to be very insightful and credible. They seem very credible. I've weighed the credibility of each of the experts regarding this topic of competency, and I find those observations to be credible from Dr. Seipel. I've observed Ms. Schabusiness interacting with her attorney. Obviously, I can't hear what they're talking about, but as I sit up here, I can see everything that goes on in the courtroom. I can see them interacting, discussing. Mrs. Schabusiness indicates she thinks she can work with him. She understands what the courtroom procedures and players are. There's been occasions of inappropriate behavior, which Dr. Seipel indicated on testimony here, that he was fundamentally unable to rule out that they are volitional in nature. Satisfied, based upon all the evidence I've received, that the greater weight of the credible evidence in this case, and my assessment of the credibility is included in that the greater weight of the credible evidence supports a finding that Mr. Business is competent to proceed to trial, and I'm going to make that finding now. So that's the decision of the court.
Okay. There you have it.
Regarding the competency hearing, that piece of this case is now concluded for today. The jury selection is scheduled to begin at 1 o'clock. I believe the jury was requested to report at 12:30, so they should be ready to go when all of us are sitting at the council table at 1 o'clock up in branch 1. And I want to just cover a few topics before we break. I alluded to this before, but I'm confirming it for the parties now. I'm going to seat 4 alternates in this case. That's a lot of alternates.
Four alternates. Okay. So this trial is just 1 week long. That should be a cakewalk for us because we've done weeks here. You know, weeks. We got a prep. The last time, what was the last trial? Letitia, with Gannon stuck and the parents and all that. I had like supplies stocked and everything prepared, kind of, you know, better prepared than any other trial. So this one should be a cakewalk. It starts Monday. Again, I'm going to be here 9 a.m. Eastern. They're in Central Time, so they start 8:15 Central. Technically starts 9:15 Eastern, but I'm starting 15 minutes early so we can settle, get whatever, hang out for a little bit, talk. And it's going to be like at 6 in the morning Pacific, okay? I already set the stream. When this stream ends, I'm going to forward you to Monday's stream. I scheduled it in advance. I have a playlist going. I'm going to put that on the front page after the stream. And so, yeah, it's going to be a walk. The other thing that's coming up is Sarah Boone. Now, people are in the chat are telling me that was moved to August 2nd, right? And I don't know if they pushed back Kohlberger yet. I don't think Kohlberger's happening. Kohlberger's supposed to be October 2nd. It was supposed to be October 2nd. I haven't followed it. What happened after? This was a while back that I heard October 2nd. Highly doubt it's happening October 2nd, right? Anybody in the chat been following the Kohlberger stuff? When is it actually happening? Do we know? So I don't see that happening October 2nd. I don't even know if they're going to stream it. They might not. We're going to look at this. This is a short video, so people that don't know the Sarah Boone, what we're going to do too before this thing starts, after this trial, I think we should probably watch the interrogation again, maybe. This is the suitcase killer. Is Kohlberger still for October 2nd? We're not going to see the trial. I don't know if October, so they both happen on October 2nd. Let's go into trial October 2nd. Boone, October 2nd. What about Kohlberger? I feel like they're not going to stream it. I gave up on catching it. Yeah, I don't know. I'm following the course. Kohlberger can't start any later than November because defense asked for a speedy trial. Okay. We'll follow up on Kohlberger. I doubt it's happening October 2nd. But Sarah Boone is happening October 2nd. So we're going to just fill in the gaps in between until that trial ever happens. And if they even ever stream it, I don't know. But Sarah Boone is the suitcase trial. This woman somehow got her boyfriend or whatever to get into a suitcase, and he's just in there saying, "Please let me out." There's actual video of it because she recorded it, and she went upstairs and I guess went to sleep, and he died in the suitcase. This is a Florida story. So that's coming up. Let's listen to the rest of this. We'll skip ahead if we have to.
But I don't want to run into troubles for the sake of not having enough alternates. So we're going to have 4 alternates, and that means, in light of the type of case this is, and in light of the fact that attorneys get 1 more strike for every alternate, that each side would be getting 10 strikes.
Judge, I think the statute requires 1 more strike if the court is going to have alternates. I don't think it has to be per alternate.
Okay. Then I'll confirm that before we start upstairs. We've got the chair set up for the appropriate
That's happening
number
today.
of jurors.
Pretty sure that's not going to be streamed.
The other question I have is,
Even if it was, I wouldn't stream it.
have the attorneys addressed the video as far as redaction? The video was very lengthy. A lot of it had really nothing going on. Mr. Saunders requested that I simply watch the part of the interview, and he submitted the time frames. Mr. Freilich requested that I watch the entirety of the video.
Yeah, I want to see the whole video. See, the trial, it's only 1 week, but it's going to be interesting because I want to see that interrogation of this lady, Taylor, if that's what they're talking about.
I guess the question is,
I'm curious about the opening statements. I wonder if the defense will even open with anything.
has that issue been addressed or not, Mr. Saunders?
This morning, I was finishing getting a redacted copy, not only the dead portions, but also the portions that were moved and essentially stipulated out. I can provide that. I would hope that's completed now. I can provide those times to counsel that were excised.
So just answer your phone or shut it off. I'm going to monitor that rule as we go forward. Everybody needs to make sure when you walk in the courtroom, I've entered in a prayer that there's going to be no cell phones
Who's phone ringing?
functioning while we're in here, with a couple of exceptions that are in the order that I published. Make sure you got your phones off, okay? Back to you, Mr. Freilich. So I guess I don't want to run into a situation where we're addressing an issue of, I got the times from Mr. Saunders, and I don't agree with them, because I want to know if you don't agree with them ahead of time so that we can address it. Mr. Freilich.
Well, what I think I could do is maybe meet with Mr. Saunders and Mr. Lassay and then talk about it, see it, and then make a decision on that. But I got to see it first.
Happy birthday, Rich.
So that's what I'm trying to prompt, because we'll have that video wouldn't be offered into evidence until sometime next week. So you'll have the whole weekend to talk that through, but I want to make sure that conversation is going on so I don't have a jury sitting waiting while we work through those issues. I did, just for the party's own edification, and I think the attorneys were aware of it because my JA contacted your office. I drafted orders based upon the motions in limine that were filed, just outlining what was granted and what was denied so that it's all clear for everyone and we don't have to spin our memory back to what happened. I would invite you all to look at those over the weekend to make sure that they're accurate. I've pored over them. I think they're accurate. So I invite you to do that. But then back to the jury selection, Mr. Lassay, your suggestion is that just simply 1 extra strike because we're having alternates as opposed to 1 extra strike per alternate?
I think so. It's 97203 is the statute that talks about peremptory challenges, and it says in a case of this nature that everyone gets 6 challenges, and then the language specifically says each side shall be allowed 1 additional peremptory challenge if additional jurors are to be selected under 97204 sub 1, which I think is the alternates.
Mr. Freilich, do you have any opinion on that?
That makes sense, Your Honor.
Okay. It's a lot easier if you stipulate, and that sounds like what I've got. So I'll review that section of the statute as well, just to make sure we're ready. And if that's the case, obviously, jurors we pull up changes. So anything else before we break? Mr. Saunders?
Judge, there was an issue that's related to, I think, the NGI evaluation. I think when the court ordered Dr. Engen to perform the NGI evaluation, the court provided access to the competency reports of the other parties, including the prior competency reports of counsel. I would ask that the state be allowed to provide, or that the court provide to Dr. Engen, as the court-appointed expert on NGI, the new reports of Dr. Litton and Dr. Seipel.
Mr. Freilich, any objection to that?
No, Your Honor, that's pretty common practice.
I think it's fair that everybody that's going to be testifying regarding that issue be allowed to access the reports. So I will order that. I guess the other issue actually that is out there is the situation with
Taylor's husband is Warren Schabusiness, and she has 2 kids. Oh, okay. One born in 2022. Oh, Lord.
Dr. O'Donnell. So let's take that up. Mr. Freilich.
Your Honor, I did, the defense did retain Dr. James O'Donnell from Illinois, toxicologist and pharmacologist. He did testify at the motion hearing that we had on the issues and the substances that my client had been using or abusing in the past. I thought his testimony was helpful and I feel it's relevant as it relates to the NGI issue. I know that the court said that I was to let the court know by a certain date on whether I wanted to have him testify, which I believe was for the trial. And I know the law, voluntary intoxication is not a defense, so I wasn't intending on having him testify at the trial. But if the case gets to a point where we have phase 2, the NGI phase, I would like to have permission to have him testify. I provided notice in June, I believe, with his curriculum vitae and a summary of his opinion.
Okay, I think
We not call.
we're done with this, right?
Thank you.
What timing goes, I've been very conscious of the timing of how things go to make sure this trial stays on time. And so I printed a copy of the transcript from the hearing that we held on June 13. And near the end of that, I noted that I think we've addressed all the motions that were set on today, other than the state's motion to exclude the testimony of Dr. O'Donnell. The state doesn't want him to testify. I go on to say, so I think that what we need to do regarding that motion is, Mr. Freilich, you need to make a determination rather promptly of whether you intend to utilize his testimony. If he indicates to you, I don't intend to use them, then your motion is really not relevant anymore, a Dahmer motion.
All right. Yeah, we don't need to listen to this. So it's happening. It's for sure happening Monday. Okay. We'll be here Monday. Let's just snip into this a little bit real quick. I want to hear about Sarah Boone. Just this is a short video.
Please raise your so help you God.
Yes.
Good morning, ma'am. Tell me your name and your date of birth.
Sarah Boone, 10-10-77.
All right, we're here for a status hearing on your case. Your case was set for pretrial conference back on July 12th, but as I promised you, I was going to bring you over, so whatever things that we normally discuss at pretrial would be discussed while you were present in the courtroom.
Anybody remember how many lawyers she's gone through already?
Mr. Banquets, in court, you previously discussed an issue with getting JAC to pay your expert, I'm going to just paraphrase, for this battered spouse defense. All right.
And they have filed a formal objection, which now has been set for hearing. I want to say September the 18th, first available time, because they have to have, they require 20 days.
September.
For hearing purposes, and we couldn't get on your docket before that date.
All right. So, Mr. Cacciatore, Ms. Boone's present. Mr. Banquets is asking to continue the case so that he can, we're going to have a hearing with JAC on his request for funding for a defense expert. Given my understanding of the case, that defense expert would be crucial to at least one defense that's going to be offered in case. And my understanding is you can't do anything until that expert actually is identified as a witness who's going to be called, correct?
That's correct. She has been identified.
I understand, but it's not unknown at this point whether she's going to be called. And I assume since there's no agreement as to payment, potentially there's going to be an issue with the state deposing her at this point in time.
Correct.
So that's what I meant by he can't do anything until you get to the bottom of what she's going to be paid and whether she's willing to formally accept the case. Is that a fair statement?
Semi-fair. She is formally willing to accept the case. The issue is the hourly rate. JAC has changed their hourly rate for this area of expertise for over 10 years.
Thank you, Mia.
So, Mr. Cacciatore, the request is to continue so that that issue can be resolved. Do you have any objection to that?
No, Your Honor.
All right. I'm going to grant the request to continue under the circumstances. What's the hearing date that we're currently working with, Mr.
I want to
Banquet?
say September the 18th, Judge.
That sounds like what my JA told me as well. For control purposes, I'm going to set the case for my September 20th pretrial, October 2nd trial period.
Okay, yeah, like you guys said, October 2nd. Okay, so September, whatever, pretrial, October 2nd. All right, so we got some stuff coming up.
There's been so many crazy stories that I'm okay. I wonder what the length of this trial is set to. And I guess maybe they're going to stream it since we're seeing some video now. Maybe they will stream it. I wonder how long that will be. There's been so many crazy stories that, like, I don't mind not being completely tied down to a trial for a long period of time, especially now when like the baby's out of school. Right now she's with her mother. I'm getting her later this evening, but you know, when the kids are out of school, sometimes it's a little tough to do these trials. So 1 week's not bad. We'll do the 1 week next week. And then in October, I guess this lady's finally getting her trial. So we'll figure out a day closer to when October. We'll rewatch the interrogation and we'll go over some of the videos for all the new people. We'll do a little kind of like a recap. Don't have to go too in depth really, because just this basics, because there's going to be lunch breaks and all kinds of stuff during the trial. We can hang out and talk about the case and all that.
I understand that we can potentially address pre-trial. And I understand that you're unlikely to tell me that you're ready to try this case on October 2nd, regardless of what happens to the 18th.
Correct.
But I just want to have the case scheduled close in time to the 18th so we can address them at the same time.
Thank you, Judge.
All right. That is the order of the court. Ms. Boone, you'll be returned to the Orange County Jail while Mr. Banquet continues to prepare your defense. All right?
Judge Boone.
Hold on 1 second. Ms. Boone, I've addressed pre-trial. I've brought you over.
Oh, shit.
I'm going to give you a moment if you want to share something else with me, but that's what I needed to address today. And I've got other matters that I need to address in short order. So
I understand, and I'm grateful for your time. I had previously sent you a letter, and it has not been uploaded, but it was made an announcement to the courtroom during my pretrial that you do have it, and I was wondering why and if it will be uploaded, because I have another copy of it that I would like to hand deliver to you today.
I don't know why it has not been uploaded. I'll have to talk to my JA about that. If you want to give me another copy, that's fine.
Yes, please.
All right. Go ahead and just tender it to one of the deputies. And actually, any objection if I just have the clerks scan it here in open court?
Yes, please. And do I normally get a copy? I haven't gotten one. I'm sorry.
Well, it'll be filed in the case.
If it's uploaded, Judge, I can make a copy and take it.
She has a letter from the judge.
All right.
Yes, please. If that would be okay, I would like to have that one uploaded. It's revised.
Okay.
They've been snubbing her for a long time.
And what I had directed my judicial assistant was to disclose this to the attorneys. Again, to a great extent, when I read the original, you've covered a great deal of ground that we've covered in open court on multiple occasions about the method and manner of communication. Having read the original letter, I did not believe there was any additional action that I needed to take, which is why I didn't take any action on that letter. All right? So to be filed, Ms. Boone will be returned to the Orange County Jail pending further order of the court.
Thank you.
You're welcome.
Boom. So that's Sarah Boone. And then I saw some people in the chat saying Koberger's October 2nd. I'm hearing that is the official date that they set, but I'm hearing that it could be delayed. Let's see something here. I wouldn't worry too much. We'll wait till the day till it gets closer. We still got a lot of time. State appeals for reconsideration of speedy trial delay in Brian Koberger murder case. Let me see what's going on with this. Recent documents of the Brian Koberger case show that the state filed a motion for the court to reconsider its order staying time for a speedy trial. Koberger was indicted. We know that. On June 13, Koberger filed a motion to stay proceedings, citing an Idaho law allowing a party to request a stay in proceedings where there has been a substantial failure to comply with applicable law in selecting the grand jury for trial. On July 10th, the court issued an order for a limited stay to the proceedings to toll the speedy trial for 37 days. Koberger and his counsel agreed to the terms. The state now requests the court to reconsider its order to protect the record of the case, to promote efficiency and predictability in the weeks and months ahead. The trial remains set to October 2nd. So I don't know. They say October 2nd. I guess we'll see. That was, this is from July 8th. So this is a recent article, July 18th. Yeah, so I don't know what's going on. I guess we'll see. I'm not going to stress out about it because I don't even think that they're going to stream it, but we'll see if it actually happens October 2nd. Idaho judge grants 37-day stay. Appears now to be up in the air after a judge granted a temporary stay of court proceedings, effectively stalling the clock on his right to a speedy trial. I don't know. So yeah, I don't know. So far, it's still for the 2nd, but we'll see. We'll see what happens. I don't stress out about that shit because all I see there is we have multiple options in October. You know what I'm saying? Whatever happens, happens. You know, sometimes people ask me like, "Oh, Mel, like, what are you doing?" I think about this. Sometimes people ask me like, "Oh, what are you doing tomorrow?" And a lot of times, wherever the day takes me, you know, wherever the day takes, something's always happening. Let me see.
Prosecutors say Brian Koberger must waive his right to a speedy trial if he wants to put proceedings on pause. Court documents filed last night show the prosecution is asking a judge to reconsider a 37-day pause placed on those proceedings last week, issued so the defense could review grand jury documents. Koberger is accused of murdering 4 University of Idaho students last year. And under Idaho law, a defendant's trial must begin within 6 months of their arraignment unless they waive their right to a speedy trial. Because of that, prosecutors argue it is possible Koberger could later say he was not brought to trial in a speedy manner and the entire case could be thrown out. Koberger's next hearing is set for August 2nd.
I don't know. So, the defense is going to file a motion. Yeah, we'll have to wait and see. We will wait and see. So, all right, man, I'm going to get off for now. I am going to transfer you to the stream for Monday. Oh, it's just a white hair? Jesus. This shit's glistening. I'm going to transfer you to the stream for Monday. Monday, we start the trial. Okay. Should be interesting. I don't know. I don't know what to expect. We'll see. Let me see. I don't have any notifications until later. 17, 18, 19, 20, 21. 22, 23, 24. I don't have any notification for 7 hours. See something? We got sweet. I'm going to take a little break. Hold on. Let me see what's going on here. There's something going on. Bomb squad responds to suspicious package. Oh, it's already off. California. Yeah. All right, man. So thank you guys so much for hanging out with me today. Thank you. I appreciate it coming early. If you haven't seen this morning's video, definitely go and check it out. Okay. If you want to familiarize with yourself with the story, some of the details of what this lady did, I'll drop it in the chat if you haven't seen it. All right. Thanks, Remy. A happy birthday to Lexa and Rachel. Happy birthday. I hope you guys have a great day. Be safe. Okay, I dropped the link in the chat if you missed this morning's. Oh, wait, did I put the wrong video? Or was that the right video?
Some viewers may find the
Oh, no, I put the wrong video in the chat. My bad. That's old. Well, the video I put in the chat is her attacking the attorney. So if you want to see that video, because I heard some people said that they missed that video. That video I put in the chat, that's for the attack. The video I'm putting now is for the story, the details of the story. If you missed that, all right. I'm going to go chill for a little bit and relax until later this evening. I think I get Maddie tonight. So, I don't know what that was. I get Maddie later tonight, all right? So, you guys have a great day. Take care. Bye. Love you. Adios. Bloop, bloop.